Brahmins, Thakur, Savarn, as they are called in Hindi, they will be specific targets.
Oh my God, something terrible has happened. Casteism, Brahminism, Manovad. Some major catastrophe has happened to the general category in this country. The Supreme Court forced me to do it. I really don't want to do it. All right, let the rules be. Who asked you to implement them?
This change is not going to help the SC, ST, OBC cause as much as it is made out to be.
And the whites say, oh my God, we would be crushed in the US. What is the name for that, Sanket? This is an ideology of white supremacy. How ill-informed the current debate is. In this instance, the criticism is coming from the ideological friends and followers of the regime. Object not only to affirmative action, but they begin now opposing anti-discrimination.
Oh God. Mr. Yadav, see, I present to you a hypothetical situation.
A lot of nonsense that's prevailing in our public domain right now.
You do know that there is and always the fear of it being misused. We have seen this in anti-dowry law, rape law. You see false complaints also being fined to malign the reputation. Hello and welcome. You're watching me, Sanket Upadhyay, on The Federal. The show is called AI with Sanket. This is the AI, not as you know it, this is the AI of news. Because news in India today requires not artificial, but analytical intelligence. As we promised you that this whole week will be dedicated to answering or attempting to answer certain questions related to the changed UGC guidelines. Now there are two parts to it. In yesterday's episode, we explained how the VBSA or HECI bill, which is proposed in Parliament, is very different from the equity guidelines which are already in effect. We are going to talk about the equity guidelines, which essentially means that every UGC controlled educational institution will have to ensure that nobody is discriminated against. This comes in the backdrop of protests and questions being raised of discrimination against members from the SC, ST and the OBC community. There have been wide-scale protests all over the country, on the internet, outside the internet, by political parties, where many upper caste or many people from the forward caste or the general category feel that in an attempt to stop the discrimination, alleged discrimination, we will now be discriminated against, where people in the general category will face huge problems, perhaps even persecution. What is the reality? Is this really going to be the case, or is this too much fear about something as simple as bringing about equality? We put this to a discussion in a conversation with a very special guest this evening, Mr. Yogendra Yadav, who has been a member of the UGC himself. So we have with us Mr. Yogendra Yadav. Thank you very much for joining us, Yogenji. As I said in the introduction as well, you have been a member of the University Grants Commission, which is in the eye of the storm right now. Would you like to tell us the objection that is being put forward by largely the general category members? What do you have to say about this, about the rule itself and this objection?
Sanket, allow me to begin by saying how ill-informed the current debate is. This is not an exception in this country. I think we've made this a norm. We have massive debates about issues in which most people, both sides, are completely ill-informed about what exactly they are debating. There are the following misconceptions. Number one, everyone seems to believe that something altogether new, either revolutionary good or very bad, has come into being. It is completely mistaken. The current rule of 2026 is nothing but a reformulated version of something that already existed. Rules about equity and ensuring that there is no discrimination in educational institutions have been in place since 2012, when I was a member. In fact, I was involved in framing of the original rules. So number one, asking higher education institutions to follow certain rules which would ensure that there is no discrimination is nothing new. That's the first complete misconception about it. Number two, the idea that the government has on its own done something major is also completely mistaken, because this entire new regulation flows from a Supreme Court case. It's not the government. Mr. Modi's government has not suddenly come up with social conscience and has suddenly come up with something against discrimination. There is an ongoing Supreme Court case in which the Supreme Court the benches have changed. Currently, it's the CJI and Justice Bagchi who had the bench. They have repeatedly said, look, your existing regulations need improvement. You need to reformulate it. So it's at the Supreme Court's direction that it is happening. And the Supreme Court has clearly said what changes they wanted done. Number three, the assumption is that for the first time, something on caste discrimination has been introduced. It is again completely mistaken. The 2012 directions also specifically named SC and ST. The current directions name SC, ST, and OBC. So there is nothing new here. So that's what I wanted to begin by clarifying, that the entire debate is standing on non-existent legs. The second step would be then to recognize where is it that the criticism is coming from. Now, interestingly, usually much of the criticism against the educational policies of the government has come from the opposition, as is normally the case. But please remember, in this instance, the criticism is coming from the ideological friends and followers of the regime. So it is the regime which is criticizing itself. It is those who believe in Mr. Modi, those who believe in BJP's ideology, they are the ones who are saying, oh my God, something terrible has happened. Now you can understand what exactly is happening. There is a pre-existing rule against discrimination. The Supreme Court says the rules are not enough. You need to tighten it. The government has no option except to tighten them. And then the government gets someone to criticize itself. You understand the game? I have to do something because the Supreme Court forced me to do it. I really don't want to do it. What would I do? I would generate a furor about it. I would generate public heat on this. And I'll say, oh my God, public doesn't like it. This is a manufactured dissent. This is a manufacturing of things in order to ensure that these guidelines cannot be implemented. And incidentally, Sanket, I've had a close look now at the previous guidelines and the current ones. The differences are such that the present debate does not even begin to capture it. The reality is that while in 3 or 4 instances, the previous regulations have been improved, and the Supreme Court was right to say that the previous regulations were loose, they needed to be tightened. However, in the process of tightening of these regulations, the regime has actually diluted some of the core content of anti-discrimination law. That is what we should be debating, not the kind of debate which is being generated, which is being manufactured.
So I think what we'll do is we'll come to you present a totally different concern here. You are saying that actually this change is not going to help the SC, ST, OBC cause as much as it is made out to be. It's actually a dilution of the intention to protect SC, ST, OBC members in universities. However, before we come to that, Mr. Yadav, would you like to tell our viewers what exactly has changed between rules that existed in 2013 when you were an honorable member of the University Grants Commission and the rules that have come into existence now? What is the key change?
What is the continuity? Let's begin with that. The basic continuity is that the Constitution of India has clearly, and the fundamental rights, there is an article against discrimination. any form of discrimination based on caste, gender, ethnicity, language, place of birth, etc., is unconstitutional. The regulation of 2012 and the regulation of 2026 simply try to implement a constitutional mandate. Let's not forget that. The manner in which the 2012 regulations implemented it, and I was part of those who drafted it, and this was the very first time it was being drafted. And at that time, it said, look, this is, it quotes the Constitution and says anything which discriminates. And please remember, 2012 and 2026, both of them are not only about caste. It is about gender. It is about physical disability. It is about any other form of discrimination. Caste is only one of them, both in 2012 and in 2026.
But Mr. Yadav, you're saying that in 2013 and in 2026, the reason why these rules have come into existence, there has been a mention of SC/ST atrocities against them. And that perhaps is evoking this sort of a response.
The rules in general, the general formulation of the rule cites all forms of discrimination. The specification in the case of earlier guideline, the specification was about SC and ST. Now it has been extended from SC/ST to SC/ST OBC. But that's only one specification. Please remember, all the provisions under this rule can be used by those facing physical disability discrimination, women, any say if there is a Hindu student in Aligarh Muslim University who feels he's being discriminated against, he can use it. If there's a girl who feels she's being discriminated because she's a girl, she can use these laws. Physical disabled who feels he's being discriminated or she's being discriminated, they can use it. So please remember, these are general rules. Only some very specific provisions mention SC/ST.
General rules against discrimination.
That's right, which is a constitutional mandate. I mean, it's astonishing that this country is debating. I mean, are we debating whether the Constitution of India should be revised or not? Are we debating whether Article 14 should be in our Constitution or not? This is the Constitution's wording. This is what the unease is. Basic unease is with the Constitution of India.
Oh God. Mr. Yadav, see, I present to you a hypothetical situation. Let's assume that there is a situation where an OBC teacher or a student has been accused of discriminating against a student from the SC or ST community. Or let's assume that a member of the SC/ST community has been accused of discriminating another individual within the SC/ST community who perhaps is lower down the caste chain. Will all of this be covered under this new equity rule or not?
Absolutely. I see no reason, unless someone were to take a hyper-technical view of it. I see absolutely no reason. Basically, the idea is caste-based discrimination. All these are caste-based discriminations. And there's absolutely no reason why they should not be covered. In fact, that's why I'm saying the debate is so silly. The real changes, the question you asked me, what are the real changes between the earlier regulations and the current regulation? The basic changes are, and all of them emanate from the Supreme Court. Supreme Court had said, look, your regulation, number one, Supreme Court said, show us the implementation of this regulation. The UGC had not checked it on all these 10, 12 years. UGC went, asked the universities. About 3,000 universities and education institutions said, yes, we have a cell. Then the UGC said, all right, how many complaints have you received? And it turns out that while there are about 3,000 cells, so far the complaints are only 1,400. So one committee has not even had one complaint so far. It's half a complaint. Clearly, all of these things exist on paper. The court was very annoyed with it. They said, which means you're not really implementing it. And then they said, okay, is the UGC supervising it? It turns out the previous regulation were defective because they did not provide for a mechanism for the UGC for a UGC oversight. They said in the previous regulation, The final authority was with the head of the institution. The court said, what if the problem is with the head of the institution? You have to provide an appeal outside this. That was done. So what the new regulations have done, they've done 3 or 4 very sensible and much needed things. Number one, there is a UGC oversight now over the institution. Number two, there is an appeal outside the institution to an ombudsperson. Number three, instead of one anti-discrimination officer provided by the previous regulation, now there is an equity committee. And number four, instead of merely looking at complaints, there are now proactive positive measures. All these 4 steps are good steps. The problem to my mind is that while it has strengthened these 4 things, and all 4 were at the direction of the Supreme Court, it has also diluted 2 or 3 things which were not asked for by the Supreme Court. The previous regulations had clearly given a definition of what discrimination could mean. It had given a list of possible discrimination. That has been done away with. The previous regulations had clearly said what is harassment, what is unequal treatment. All those things have been done away with. So while in principle all those may be covered, but when the law had very specifically given instances, it was a strong law. It has been diluted. Now, this is really the change. The rest is a lot of nonsense that's prevailing in our public domain right now.
Mr. Yadav, you're saying that there was a clear definition or an outlay of what discrimination and harassment is in the old set of rules, and that in the garb of fulfilling a mandate by the Supreme Court, the government has done away with, thus introducing a certain amount of ambiguity, which is going to be counterproductive. That is not going to really help the SC, ST, OBC or anyone in their fight against discrimination. However, do you feel that by removing this definition, however it may have been, a definition may have been widened, having a wider spectrum of understanding of what discrimination is? Or have they just not defined it completely?
No, it's not been widened. Please remember, last time also it was a wide definition plus examples. Now all the examples have been removed. And the point about examples, you could say, well, examples are superfluous. How does it matter? You don't need examples in law. But when a law specifically says, for example, the previous regulations clearly specified what kind of things happen in educational institutions. Discrimination, not giving them marks, discriminating in the classroom, discriminating during examination. All forms of things were possibly listed. When a piece of regulation or law lists these things, then it becomes very easy and possible for an aggrieved party to go and say, this is what's happening with me. Now the onus is on the aggrieved party to say that what's happening to me should be defined under this very omnibus category. So that makes it that much difficult. It's not impossible, but that is the onus is shifted. So in that sense, it has been diluted. The institutional mechanism has been strengthened, but the core definition has been diluted. This is exactly what has happened from the last one to this one.
So do you think this is going to help the cause of women or men who are being discriminated against, or it will not help their cause?
Look, in the last instance, regulations are the way they are implemented. 2012, we passed the regulations. And I'm sorry to say they were very, very poorly implemented. And, something must have been wrong with the original regulations themselves because they could not be implemented that well. But also, it is the institutional mechanism that defines. So yes, as a piece of law, I would really have wanted the Supreme Court to revisit it. The Supreme Court, I hope, because Supreme Court has kept the possibility open and has told the petitioners, if you are unhappy with the regulations, come back to us. I do hope the Supreme Court will take a look at it. I do hope the Supreme Court will ask the government, we asked you to do the following 3 things. Why are you doing this 5, 6, and 7, which we didn't ask you to do? So maybe that can be improved further. But the real key, this is one thing I've realized after all these years of being in public life. What you write in textbook does not decide what happens in the classroom. What you write in laws and rules does not decide what actually happens on the street. The real key is implementation. And to my mind, the controversy that is being generated as if some major catastrophe has happened to the general category in this country, that is basically in order to ensure that whatever the regulations are, they are not implemented. Just imagine, just for a comparison, I want to tell you what is the complaint. The complaint these days, the complaint is, oh my God, general category students are being discriminated against. Now, this is like saying, and they're saying, why don't you identify general category students as potential victims? Now, this is like saying a law on gender or on sexual discrimination should specifically identify men as targets of gender discrimination. It's rather odd. Or to say in the US, every law on racial discrimination must identify whites as possible victims of racial discrimination. When I say this about US, you would smile, anyone would smile, कि यार किस देश में रहते हो, क्या बातें करते हो, है ना? But we say exactly the same things in this country. So to my mind, what we are witnessing is a backlash. It's a contrived, artificially generated backlash in order to ensure what this regime has to do as per the Supreme Court guidelines. They are not required to do so. Even if they do so in paper, it is not implemented. That, to my mind,
how is that possible, Mr. Yogendra Yadav? I can understand that the Supreme Court has mandated something, you have done it, and let's just assume what you're saying is the real cause, that the government either directly or overtly or covertly is manufacturing this dissent or this criticism against this new rule. How can they not implement this rule then? Are you trying to say that psychologically they would have watered this in any complaint down? So it may exist on paper, it will never reach the ground.
Sanket, I can see two possibilities here. One possibility is the government could say in the coming few days, we have received very strong feedback from the public. We will look into it, and here is a committee. And the committee would tweak this in one or two respects, which would actually not just further dilute. And there are, all kinds of ways of bureaucratically scuttling something which needs to be done. So that's one possibility. The second, and equally likely possibility, perhaps more likely, is, all right, let the rules be. Who asked you to implement them? This happens in this country again and again and again. You have a lovely piece of law, and someone winks at you that let the law be. Lagu karne ki kya zarurat hai? This is unfortunately what happened to the earlier regulations. And I suspect that we have reached a stage in our public discourse where earlier the protests used to be against affirmative action. Earlier the protests were if you were giving something to the historically disadvantaged communities. Now the threshold has been lowered. Now we have backlash even against anti-discrimination, which is a much lower thing. Even against that, this is happening. And that is what I fear might really happen.
Mr. Yadav, again, since we are dealing in hypotheticals, so all my questions have to be premised around them. The concerns, I'm sure you must have heard from all these protests that are taking place, is that these new laws are going to specifically target the general category individuals, students, teachers from the general category like Brahmins, Thakur, Savarn, as they are called in Hindi. They will be specific targets. Number two, they will have no grievance redressal. The onus of proving themselves innocent will be on them and not the other one. It is going to malign their education, malign their reputation, and they will have no redressal. What do you have to say about this?
Sanket, if you see a smile on my face, it is not because I take delight in anyone being persecuted. Even a single person being persecuted for wrong reason is very bad. But that's why I began by saying, Sanket, the whole debate is so ill-informed. Please remember that exactly this regulation has existed for the last 14 years in this country. How many such cases have happened of the kind that people are talking about? How many targeting of the general communities has happened? How much persecution of the Savarnas has happened? In 14 years, please get me 14 cases. What is new about this thing? And this, in a sense, is really like saying, and that's why I come back to what I said earlier, that you have laws against racial discrimination, laws against discrimination against ethnic minorities in the US, and the whites say, oh my God, we would be crushed in the US. What is the name for that, Sanket? This is an ideology of white supremacy, which expresses itself in this language of anguish. When you have anti-rape laws, when you have anti-dowry laws, and a group of men says, oh my God, men of this world are being discriminated against. What is the name for that, Sanket? The name is patriarchy. Patriarchy expresses itself in this artificially contrived sense of hurt. And that is why when those who are dominant in this society, they object not only to affirmative action, but they begin now opposing anti-discrimination. The name for that should be casteism, Brahminism, Manuvad, attempt to impose caste domination in this country. I'm afraid that's the only name for such contrived expressions against this particular regulation.
But Mr. Yogendra Yadav, my last question. You do know that for any rule to exist in this country, there is and always the fear of it being misused. That is also a reality. We have seen this in anti-dowry law, rape law. You see false complaints also being fined to malign the reputation. Let's just assume that there is one case, which is one too many, of one person being wrongly accused of doing what he or she has done. In that case, what should be the guardrails to prevent something like this from happening in this law?
There already are several guardrails or regulations. In fact, the laws that you mentioned, anti-rape law, SC/ST Atrocities Act, etc., and anti-dowry law, they are actually really very stringent. They are on the other extreme. In anti-rape law, the moment I'm accused, the onus is on me to prove that I'm innocent. There is nothing of that kind in this particular regulation. It's a very normal, straightforward regulation. If you think a wrong case has been brought against you, go to the committee. You're not happy with what the committee has done. Go to the higher authority. You're not happy with what the higher authority does. Go to an ombudsperson who is above and beyond the institution. There are 3 appeals. What more do you want?
For me, the big highlight of this conversation with you, Mr. Yogendra Yadav, is you saying that this is a pro-government manufactured protest which is going on to dilute what the government has had to implement because of the Supreme Court. Am I right in my submission?
That's a fair summary. And in order to check whether I'm telling you whether my reading is right or not, why don't you go to the social handles of all those who are opposing this particular regulation? Please check what they have said about Mr. Modi. Please check what they say about BJP and RSS. And please come back and tell me if I'm wrong.
I'll definitely do this. But thank you very much, Yogendra Yadav, for putting things in perspective. I couldn't think of a better person than you to perhaps help us understand what this outrage is about, as you were a member of the UGC when this rule was drafted for the first time. Thank you very much for joining us, Mr. Yogendra Yadav. Thank you.